in fact, having communication, but he felt he was role-playing with an adult. I'm asking the court to consider giving him probation as opposed to sending him to prison.
I don't understand how he thought it was role play when the images were not of an adult. All right, we're going to go 387 State of Texas versus Alberto Hernandez. Could I have parties announced for the record for the state? Defense.
Monica Guerrero for Mr. Hernandez.
And are you Mr. Hernandez?
Yes, ma'am.
All right, you entered a plea on July 18th to count 1 of no contest, count 2 of no contest. You applied for community supervision. The court found there was sufficient evidence to find you guilty in each count, and the court found you guilty in count 1 and count 2. Have both parties had a chance to review the PSI report, state? All right, defense?
I have.
Yes.
Defense, do you have any objection to the PSI report?
I do not, so long as you have the supplemental in the back showing the correction for the ag robbery and with the ag assault and the robbery. The robbery was reduced to a misdemeanor and the aggravated assault was dismissed.
Yes.
So he doesn't have those felonies in the calculation for felonies and misdemeanors.
All right. All right. State, do you have any witnesses?
No, Your Honor.
Defense, do you have any witnesses?
I do not, Judge.
All right, then the court will hear argument. State, you are, according to the plea bargain agreement, you're asking that punishment be assessed at 8 years in the prison, and you're opposing his application for community supervision.
Yes, Your Honor.
All right, you may proceed.
Briefly, Your Honor, very brief. You've read the stipulations, you know the facts of the case, and you've seen the PSI. I draw attention to his criminal history, specifically the transporting moving aliens, knowing said aliens enter or remain in the United States contrary to law, all done for the purpose of commercial gain, advantage, and private financial gain. In the United States District Court of Texas.
All right, defense.
And Judge, I'm going to call your attention to if you look at his criminal history, although it sounds like it's a lot, it's not that much. And that case from the feds was in 2006, which was his last time of really being in trouble. We're now in 2024, it's 18 years later. If you read the PSI, you can see, well, he accepts responsibility, but he's telling me that it was not, as it appears, he was not coming down to San Antonio, that he was, in fact, having communication, but he felt he was role-playing with an adult. I'm asking the court to consider giving him probation as opposed to sending him to prison and giving him the maximum probation so that this court will have plenty of time to ensure that he receives treatment and that he complies with everything, because I've told him that in this court, it is dangerous for him to get probation because you will give him a chance and you will give him an opportunity, but if he messes up, he will have to pay. So I want the court to be able to have that leash over him, so to speak, so that he can comply with any regulations and treatment that the court would deem necessary in this type of case.
Right, I don't understand how he thought it was role play when the images were not of an adult.
Apparently what he discloses to me is that he's had relationships with adult women that pretend to be younger and send images like that, but that are actually older than him or his age.
All right, so I don't have any legal proof of that. I don't have any text messages that show that. Okay. All right, is there anything else?
No, Judge.
All right, then the court is going to deny your application. Court will find you, as previously stated, the court found you guilty of count 1 and count 2. In count 1, the court will sentence you to 8 years in the prison. This will run concurrent with count 2, and the court will sentence you to 8 years in the prison. Give you credit for any time served. Is there anything else with regards to sentencing? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
This one that you sent.
Yes, ma'am.
Did you understand it and sign it?
Yeah.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, And because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. And counsel, I did have the supplemental.
Thank you, Ron.
Thank you. Thank you for your patience. Mr. Basil, the court had considered your argument. The court reviewed Article 42.037 with regards to restitution, and based upon that article of the court's, it's in the court's opinion that the court can still order restitution in this case. And I'll let you place on the record whatever you would like to place on the record as it relates to that. And
Yes,
then
Your
we'll
Honor.
speak towards the restitution.
It's the defendant's position, Your Honor, that since this court granted the deferred adjudication on March 7th, 2024, and at that time in the court's judgment, there was restitution was listed as 0. And on the conditions of probation, there was no amount of restitution listed. That by rule of law, that order became final after 30 days. And became a final order, just like if the defendant wanted to appeal, he didn't want deferred adjudication, he would have to have filed that within 30 days. On June 12th, the supplemental request was submitted for set the case for restitution hearing, which is more than 30 days after that, and is the defense argument, Your Honor, that the court at that time does not have the authority to go back and change the judgment. And I've submitted some cases. I wrote them down. My computer's battery's about dead here, so I'll have to read them off the paperwork Your Honor gave you.
Yes, no problem.
Cases that I've researched, and while there's not directly, so court knows they're not directly on issue because they're mostly talking about probation. And I understand the statute that you're talking about mentions probation. Most of the time, there is some places in there it does talk about deferred adjudication on there. It's Cox v. State, 445 Southwest 2nd, 200. That's the Texas Criminal Court of Appeals, 1969. Bailey v. State, 160 Southwest 3rd, 11. It's also Texas Court of Criminal Appeals, 2004. Ex parte Cavazos, 2003 Southwest 2nd, 3rd, 333. Texas Criminal Appeals, 2006. And ex parte Roberts, which is 409 Southwest 2nd. Southwest 3rd, 758, Texas Appeal, San Antonio, 2013.
All right. Thank you.
Those are the cases that were provided on the notes to the court that I'm relying on, other than just the general, also under again, under notice provisions under due process clause, United States Constitution, the 5th and the 14th Amendment, and the Texas Constitution, Article 1, Section 19, which requires that he be given due process before any life, liberty, or property is taken from him. And it's our argument that since that order was final, the court does not have the jurisdiction to do that.
All right. And the court will note for the record that on March 7th, 2024, as a part of the plea bargain agreement, the court ordered that restitution was to be determined to Kenyana, Keyyana Warner. And according to the plea bargain agreement, the plea bargain agreement stated that restitution was to be payable to Keyyana Warner, the victim in cause number 708710. That was a part of the plea bargain agreement that was agreed to by Mr. Juarez on that day. And that is a part of the contract that he signed. With regards to the judgment stating that no restitution, it states $0 restitution. The court is finding that that was an error. It should have been that restitution was to be determined. And this case has been reset more than once for both parties to come together to see if there is an agreement on restitution. The first restitution hearing was scheduled for June 25th, 2024. Then it's reset for July 18th, 2024 for the state to obtain proof that the complainant did not use insurance. And that was at the request of the defense because the complainant had a deductible. Then it was recalled for August 1st, but defense attorney was ill. And then it was recalled on August 1st because the defendant was ill on July 18th. And then on August 1st, we were to have a restitution hearing and a witness was allowed to appear by Zoom. And now we're here on September 12th. So have you all come, the court has received documentation of a preliminary estimate for restitution. And they put that total at $6,399.22.
That's correct, Your Honor. I've received that. I've reviewed that with my client, and my client is desiring to have a hearing and evidence presented on that amount. I've discussed that with him in detail last time and further detail today in the courtroom.
All right, states you'll need to have witnesses here then for this being the amount of restitution.
When you're
How long will it take you?
I will need to ask Ms. Warner, so I don't know right now.
All right, so what we're going to do, and this is going to be the last setting that I'm giving everybody for restitution.
Just so the court knows, Your Honor, I will be out starting tomorrow through next Wednesday. I'm having a medical procedure
No.
done tomorrow, and I will be back. So I'm just...
All right, do you want to do it, is October 21st good for you or no?
No, that's fine. I mean, I'll be back before then. I just want to let the court know if you want to do it next week, I'll be out.
Okay, no problem.
And Your Honor, I should be able to secure it by October.
All right, Norma, this case is going to be recalled October 21st, and this will be the last setting for restitution.
Your Honor,
Yes.
will Ms. Warner be allowed to testify via Zoom? There is no objection from defense counsel.
I have no objection to that.
All right, she'll be allowed to testify by Zoom.
But Your Honor,
All right, thank you. All right, you all are excused.
Thank you.
Thank you. And Ms. Ferguson will give him a reset form.
yeah, it's gonna be.
All right, is there any other cases we have on the docket or are we done? Yay.
Inside a tense Texas courtroom, Alberto Hernandez faced serious charges tied to online solicitation of a minor. What initially sounded like a routine sentencing hearing quickly became an emotional confrontation as Judge Stephanie Boyd examined the disturbing details behind the case. Hernandez had already entered no contest pleas to 2 felony counts, but the biggest question remained whether he would receive probation or years behind bars. His defense attorney fought hard to convince the court that Hernandez believed he had been communicating with an adult pretending to be younger online. She argued that it was role-playing, not intentional predatory behavior, and asked Judge Boyd to consider treatment and probation instead of prison. The defense also pointed out that Hernandez had stayed away from major criminal trouble for many years. But everything changed when Judge Boyd focused on one critical detail. The images involved were clearly not of an adult. Her sharp questioning immediately exposed weaknesses in the defense's explanation, and the atmosphere inside the courtroom became painfully tense. After hearing both sides, Judge Boyd rejected probation completely and sentenced Hernandez to 8 years in prison on both counts. The hearing ended with a chilling reminder that some explanations simply cannot survive the weight of undeniable evidence.